So, all right. Well, I think we're ready to jump into slide 3, Diana, and that's going to be Hank, who's going to jump in and talk a little bit about what is supported decision making. Hank, take it away.
So my sense is that all of you are going to be extenders, because you're going to take the information that you're going to get tonight and you're going to use it in your life, you're going to use it in your work, and you're going to carry it to families and clients and introduce them to the topic if they don't know about it. And one of the ways you can do it without being being too oppressive about it, you can just refer them to this website, which is the one you're looking at, which is about supportive decision making. And the website, I think the address for that is sdmnevada.org. And I like to suggest to providers that they offer that to their client base, because then they're not lecturing them or anything. They're letting them see the website, review it on their own time, and then they can adopt it within their own time frame. So one of the things we want to talk about a little bit tonight is what is supported decision making. And I like to think that it's a link to self-determination. And in doing that, you got to think about supported decision making, that it's a tool that allows a person with a disability to retain or obtain their decision making by choosing supports to help them make choices in their life. And what's really fun about this, which Alex and I talk about all the time, is that this is the least restrictive method of decision making, in any kind of a system. So historically, when I was practicing law, I probably did 1,000 guardianships, 1,000 of them. I can tell you today that not one of them, well, maybe 10 of them, had to deal with the actual person's decision making. Most of them were done because we had to get some kind of a court order to meet the requirements of a government agency. So if we had had a concept like supportive decision making in place, none of that would have been necessary. And the persons that were subject to those disabilities never would have had to gone through that process. The families wouldn't have had to deal with it, and would have been a more just system. So supported decision making is a process to achieve and maintain independence and self-reliance. It's about making and selecting choices. So a person-centered planning is what it is, and that's the process of developing a plan for the future. And the goal is to reach a point of self-determination. And if you have the plan, then you're working towards self-determination, which is taking action in your life to get things done you want and need to implement the plan. So that's where we're kind of going with this. And I like to think about it is that supportive decision making, if you read the statute, it doesn't talk about people of a certain age. It talks about adults. So I'm in my late 70s, and I've incorporated concepts of supportive decision making into my durable power of attorney for health. What happens if I need a placement at some time? What are the processes that are going to go through? What is my agent going to do to help me? Are they going to recognize concepts of supportive decision making and making choices? And that's what I've directed. So this affects everybody. But there's a couple of things we've got to talk about. And these are the articles of faith as it regards to students and young people. Students and young people with more self-determination are more successful. Guardianship decreases self-determination. Supportive decision-making increases people's ability and right to make their own choices. And I think this is the best part, or it's an important part, and that is supportive decision-making promotes inclusion. So I think these are all great things we have to think about when we're helping our clients or working with this in our own family. So one of the issues is, well, what's the barrier to supportive decision-making? Really, there's none, except for sometimes parents are fearful. and they think that a guardianship is going to make their child, their young adult child, more safe in the community. And I would suggest that it won't. And it's just the issue of having some access to control in case something, adverse comes up. But with supportive decision making, other documents that we may talk about tonight, I think there's an adequate structure that doesn't require a guardianship. How did we get to this point? Well, none of us have all the answers, but back in 1979, the United Nations Commission on the Rights of the Disabled wanted to have some kind of a decision-making process in place for people. And at that time, the thinking was, well, let's use these guardianships. And it wasn't until about 2000.
And nobody.
And so it was about 2005 that the same commission came up with the idea of supported decision-making, and then it just spread quickly. And that's the basic concept that we have now, is using supportive decision-making.
Yes, and I think we have a short video now that Diana's going to play from the website that Hank is referring to. This was put together in collaboration with Center for Excellence in Disabilities and the Self-Determination Law Project. So Diana, take it away. As the video is getting ready, I will note that I don't know if this was sent out before, but you can have access to it online, and that is the actual Nevada statute. It's Nevada Revised Statute 162C, and it's called the Supported Decision-Making Act. And I saw somebody asked about definitions. All of those definitions are found in the act. I'll leave it to the video right now, and we'll reconvene in a second.
Everyone needs support to make decisions. Some need more support than others. What support do you need? Some people need help to understand information. Some people need help reading information. Some people need help finding information. Some people need help thinking about new ideas or options. Supported decision making is all about identifying a circle of support who will help you. Then you can create a written plan that outlines all the details. A plan that you can share with anyone in your life who needs to know, like your doctor, teacher, or landlord. It's all about surrounding yourself with people who can help you make the best decisions for yourself, because ultimately you will make the final choices for your life.
Okay, so that's a nice introduction from the folks over at the Self-Determination Law Project and said, and focuses, have some nice background music while I'm speaking, but yeah, and it focuses on that fundamental part with respect to this law about disability rights. And I think for those on the call, and I see many passionate advocates on the call today, they're familiar with the slogan of the disability rights community: nothing about us without us. And that's so important when we think about decision-making and a person with a disability accessing the community and being included in the community, like Hank had pointed out. And supported decision-making in Nevada and at a nationwide level is focused on that principle: nothing about us without us. Because essentially what it does is it allows the individual to not lose rights that are lost under guardianship. And it keeps that decision-making ability with the individual. So you do not lose the ability to live a fully inclusive life where you are making the decisions, right? And that's what we talk about when it comes to ideas like self-determination and self-advocacy. Those are the building blocks to an inclusive community. And this is a law that actually upholds those ideas and allows individuals with disabilities to live self-determined lives. Hank also talked about the idea of person-centered planning. So I see folks that I know from state services on the line right now today as well. The person-centered planning process, when it comes to services, is a revolutionary concept that says the person is at the center of the services and is in charge. Supported decision-making is the same concept, and it keeps those decisions and those wants, desires, and needs of the individual at the center of all aspects of that person's life. So it merges nicely with the way state services are provided in Nevada with similar type philosophical concepts like person-centered planning. Also, people with disabilities should be able to live in the most integrated setting, in the setting that they want, so they can make decisions. This law allows for those decisions to remain with the individual, and when the individual is in charge, it is going to be the choice for the most integrated setting appropriate, and the most integrated setting, the most inclusive setting. And that's really integral to that, to this idea. And if you watch some of the videos on the website, and we were interviewed just the other day, and by one of the local news stations, and we were talking about the power that the Supported Decision-Making Act, that the concept of supported decision-making has literally allowed individuals to make choices to remain integrated in their homes, to remain out of institutionalized settings or settings that might be more restrictive, because the person says, this is where I would like to live, and they are making the decisions. So it's a really important piece of this discussion. And also, the supported decision-making agreement, importantly, is focused on the concept of interdependence. And that is so essential when we think about the disability rights movement. It is a collaborative effort. It is the beloved community that Dr. King has talked about when Dr. King was advocating for integration, inclusion, and a beloved community. And that's what's going on here with supported decision-making. It's about that concept of support and interdependence, that we all are in a community and that we all support one another. And the law is revolutionary in allowing for individuals to not only select who they would like to support them in their journey, but allow those supporters to have some ability to be there with the person in support while not being in control of that individual. So it is a very natural structure that allows for individuals to have the control over the decisions that they make. And I see Dawn putting in the chat box here, definition: independent living, interdependent living. Yes, self-determination and consumer control. That is so important. And I think that when we talk about independent living, it is not meaning do everything on your own. It means I know when to ask for help and how to ask for help, and that I am in a community that is caring and inclusive. And that's what we are creating. And this is a law that allows for that. And to look at the history, I remember when I first moved to Nevada, and many of you may know Mary Bryant. She recently retired and is a fearless advocate of individuals with disabilities and responsible for some real monumental legislation over the years. And Mary would she was the first to introduce the concept of supported decision-making to me in some discussions that we were having. What was interesting is this was a discussion of individuals with individuals with disabilities and their families, but there weren't lawyers at the table. When I would talk to lawyers about the idea, it hadn't really made it into the law. But here we are, roughly a decade later, and the work of the advocates that started with individuals with disabilities is now present in law and in state law. I will note too this, and I think we lost the slide, Diana, but one of the elements of this slide that we're talking about right now is about supported decision-making in Nevada. And I will point out that guardianship laws and laws that apply to decision-making in this context, it's not federal. These are all state laws. So each state is going to have a different law. And it is actually right now, the state of California is working to implement a supported decision-making law in their state. So they're in the process of lobbying to get that passed, that legislation passed. So we can see that we are in Nevada, in this instance, ahead of some other jurisdictions with respect to this structure for understanding supported decision-making and having something in place for individuals to have that self-determined, integrated, inclusive life. And again, at the root of this, throughout this presentation, Just keep that in mind. Nothing about us without us. That is the foundation of this law. I believe we're ready for the next slide. I talked a little bit about the supporters, and Hank is going to talk about the participants. Who's involved in supported decision-making when we put together this agreement that allows supported decision-making to come into existence. So Hank, take it away.
Alex and I, through doing all this, he's well aware of my limitations with these computers, so bear with me. So if you're going to do a supportive decision maker, there's making an agreement, there's really three parties involved. And of course, the most important person is the person with the disability. And under the law, that person's called the principal. And so they're the primary person that's going to be the focus of this agreement. The second person is a supporter. The supporter is chosen by the person with a disability. And we'll talk about the role of the supporter. And then there's the service provider. That's the person that's going to, the doctor or therapist, physical therapist or something that's going to provide the service. So a supporter is often someone who's known and trusted by the principal. They have to have the time to get things done. And they have to do the task required with some level of care and competence. So you don't want to necessarily appoint Aunt Josie, who's living in Florida, who comes out for a visit every July. I don't think that's going to work. So you want to have somebody that's close, trusted, wants to do the work, and will do it with a reasonable amount of care and competence. What the supporters do is they help gather information. Okay, help discuss the information and the options, help weighs the pros and the cons of a decision. They assist in communicating the decision to others. So you could have a situation where a student is 19, they're in an IEP, and they're trying to communicate the young person's choices about a subject to school district staff. And that's part of the role. The service providers, what we're trying to do with service providers is we want them to recognize the system, and that it's crucial, because if not, everybody goes their own separate ways and nothing gets done. So the law encourages the service provider to participate in supportive decision making by giving them immunity generally for carrying out a decision of the person with a disability. And the immunity is given to the provider so long as the provider is acting in good faith. Okay, so those are the basic things we want to work on, and we want to think about those three parties: the principal, the supporter, and the service provider. Now let's think about the supporters a little bit more. You could have co-supporters. You could have supporters for different subjects. You could have a supporter that was going to be your supporter for education. You could have a supporter for healthcare. You could have a supporter for finances. You could have co-supporters. And in your agreement, you could name your first level of supporters, and with the idea that if something happened to that supporter, that person moved away, your successor supporter would step up. So these agreements are flexible. They can be redone and revisited and stuff like that. But the idea is to make them work and carry out the principal's goals.
I think we have another video here, which is why it flipped over there. And again, the essence of supported decision-making is those three categories of individuals and an agreement that is created. And we're going to talk a little bit about what that agreement looks like right after this next video. I think, Diana, there's some audio issues here.
So I probably have this can help me with my own situation.
And I help you explain things to the doctor too. And sometimes the doctor doesn't understand what you're saying. And I can help the doctor know what you're talking to.
Yeah. Welcome. I have an agreement for you when you look at.
Okay. Exactly what is this?
Yeah, I can help you. This is to allow me to help Jack make decisions about his healthcare.
Have you been tired or have you been jittery?
What's this?
Jittery means like you feel like kind of antsy and shaky and a little bit hyper.
Have you been that way?
No.
Okay.
I've been helping Jack his whole life with all sorts of decisions. I'm 10 years older than he is. And so since he was born, I've been helping to be an advocate for him and to help him decide what the best choice would be for his life. Really have to make sure that you aren't doing what you think the best choice for what you think the best choice is for the person that you're supporting. You really need to know and talk to them about what they want and what choice they want to make, and support that, even if it's not the choice that you would make personally. Jack does not like to wake up early. He likes to wake up afternoon on most days, and a lot of times I think it would be better for him to wake up a little earlier and have a morning and get things done. But in his life, that is not an enjoyable experience. So I have to help him plan things for the afternoon or evening so that he can have the mornings the way he likes and enjoy his life the way he wants to. And then he can still do the things, but at a later time.
Or ask your friend, maybe you ask your brother, and this was just too.
It's important to ask someone who knows you, so that they know how to explain what you're saying or what relates to you, and how best to explain things, and who knows your life, and so who can help you make the best decision for yourself.
I just think somebody to help them when people want to help someone. People ask your father or your sisters, maybe your friends, maybe your best friend, and have somebody you want. It's very good to ask.
It's important that people who have a hard time making decisions have somebody who can help them and who can explain things and who can help them make good decisions.
Okay, so you could kind of see supported decision-making at work right there. And that's what is possible. And you see that the individual is able to make those decisions with that support. And you could see support can be applied in so many different ways. And the example of the supporter explaining the definition of a word, so then the individual is able to respond meaningfully in that context. Before we get into the specifics of the agreement, I want to talk a little bit about the idea of what supported decision-making is. And there's a question that came up here about if supported decision-making is what we used to call a microboard, which is a technology that was used previously to assist somewhat like person-centered planning that was self-driven and self-determined. And that is a good representation of the philosophy of supported decision-making. And essentially, supported decision-making is one of the least restrictive manners of decision-making because it keeps the decisions with the individual. And I said before, it's worth taking a look at the law, which is Nevada Revised Statutes 162C. It's actually the Supported Decision-Making Act. And Diana is going to send that out to all participants on this call to be able to review, because that is the essence of what we're talking about here. And the law itself states, and I will read, that an adult should receive the most effective yet least restrictive and intrusive form of support, assistance, or protection when the adult is unable to manage his or her affairs alone. So we think about this kind of like on a continuum. And on one side of the continuum, we have supported decision-making and an agreement for supported decision-making. And in between, we have different levels of support that ultimately lead to the most restrictive setting, which is guardianship. And as Hank and I say, guardianship is the last resort because the lesser restrictive alternatives give the individual the most rights and the most ability to remain in control and in charge of their lives. So this is the least restrictive manner of decision-making that exists in Nevada law. I will also note that there's statewide guardianship rules that's been promulgated by the Supreme Court of Nevada. And when a person is in guardianship, they are appointed by law. This is started in 2017. Every guardianship proceeding, the person who is either a protected person who has a guardian or a proposed protected person where there's a petition for guardianship is appointed an attorney. And that attorney under the statewide guardianship rules is required to look into those lesser restrictive alternatives and investigate if there might be other options that do not restrict and limit as much as guardianship does with respect to the ability of that individual to make decisions. So Diane, I think we're ready for the next slide because this is the big question that often comes up is what is the difference between supported decision-making and guardianship? And it's this fundamental philosophical concept of the difference in types of decision-making. On one side, we've got supported decision-making. That is, you make decisions with support. On the other side, the most restrictive is substituted decision-making. So those are the two types of decision-making that we can, when we conceptualize these concepts. And substituted decision-making means somebody else is making the decision for that individual. So the essential difference between supported decision-making and guardianship is supported decision-making, it leaves the decision-making with the individual. Guardianship is substituted decision-making, and that means somebody else is making that decision. Now, there's so many differences then from there between guardianship and supported decision-making. I will point out a couple right now that are very important when we think about these concepts, because often folks think of guardianship as a way, like Hank had said, of providing support, of providing help and assistance. But at the same time, guardianship does take away a significant number of rights because a person is found, and this is the language of the court of the law, by clear and convincing evidence that a person lacks capacity, that a person is incapacitated, and therefore is unable to make those decisions, and somebody else makes those decisions for them. So that is a finding of the court that somebody else is then appointed to make decisions on that person's behalf. That is the opposite of the supported decision-making arrangement. Another area worth noting is that supported decision-making is an agreement between the individual and the supporters, whereas guardianship is an appointment from the court that does require court involvement. Supported decision-making, unless if it's used within the context of a pre-existing guardianship, does not require court involvement. These are the essential differences between these concepts. But again, it's supported decision-making versus substituted decision-making. And I will add that supported decision-making does not take away any fundamental rights from the individual like guardianship does. When you have somebody who's substituted to make your decisions, you will lose rights. And those rights are very significant. As I've heard said before, it's often been observed that a person who is appointed guardian may lose more rights than somebody who is convicted as a felon. So there is a distinct number of restrictions that exist with a more restrictive guardianship arrangement. And I'll talk a little bit about this right now related to what if the person with a disability is already in a guardianship. Well, the most supported decision-making agreements that are for individuals who've had a guardian for a long time, and this is a picture of Connor right here, you'll hear his story in a little bit, but when you have an arrangement where guardianship already exists, you can use supported decision-making as a way to replace the guardianship. Because if you think about it, supported decision-making has only been in law in Nevada since July of 2019. We were talking about how new this law is. So those guardianships that are in existence before 2019, this was not an option under Nevada law. So if there is a guardianship already in place, supported decision-making is often a resource and a tool to use to say a lesser restrictive alternative is possible. However, because a guardianship means a court has appointed a guardian over the individual because the individual has been found to lack capacity, the guardianship would then eventually need to be terminated through a petition to terminate, and then the rights would be regained. Power of attorney, there are power of attorney options that exist. And if you think about supported decision-making versus substituted decision-making, power of attorney is kind of right in the middle. And that does not require court involvement. And an individual identifies that they would like somebody to act on their behalf, whether it be for financial reasons or medical decisions, to act on their behalf. It's kind of a substituted decision-making arrangement, but without the severity of, say, losing rights and having an appointment from the court. If a person has a power of attorney, supported decision-making agreements are able to work in conjunction with that power of attorney, or in certain circumstances, replace that power of attorney if it is a lesser restrictive option that the person chooses. So the power of attorney, which exists prior to supported decision-making, is a good tool to work with supported decision-making in conjunction with supported decision-making. I will note that in 2015, we were able to have a power of attorney for medical decisions that was put into Nevada law, and that allows a power of attorney for medical decisions to be written in a way that is for that supports individuals with intellectual disabilities. So power of attorney for medical decision-making in the state of Nevada, there is an option that allows for a more inclusive opportunity for individuals with intellectual disabilities to have access to this option of a power of attorney. And that's also, yet again, another lesser restrictive alternative to guardianship. And I will note, power of attorney and guardianship, both of those scenarios, it's the person who decides who's the supporter. It's the person who decides who's the agent. Whereas with a guardianship, it is not necessarily the person who makes that determination. It is, in fact, a person who is behind the bench, the judge who does the appointment, and the petitioner who's saying, I'd like to be the guardian. And I know we're getting a lot of questions right here. We'll get to some of those. I see a question about a trust and a few questions about in general. I'm going to entertain this question right here. How does it work if the person with a disability isn't always able to communicate their desires clearly, even to their supporters? Well, that's where accommodations would come in. And that's where structures of support would come into play to find what is the most meaningful way in which the individual can provide support. Every individual has a way of expressing and communicating, for the most part, their wants, needs, and desires. And a supported decision-making agreement can be done in a way that tries to integrate the different ways in which a person can receive support. So that's a good question, because the supported decision-making agreement for an individual who may have more significant needs could be composed in a way that allows for that individual to have creative options in place. When we talk about support, it's not just the individual, but different strategies that exist to support that individual. And that's an important component of supported decision-making. It's going to be specific to the individual. With respect to how supported decision-making is different from a durable power of attorney, well, like I just said, it's important to remember that supported decision-making is that agreement that exists for supporters to come in and receive that support. Durable power of attorney is that substituted decision-making. Durable power of attorney also is something that can be used if a person should later lose capacity, then that power of attorney can allow that agent to assist or make those decisions at that time, which is another lesser restrictive alternative to guardianship. And I know Hank has a couple of comments on this topic and the next slide related to healthcare power of attorney. So Hank, I'm going to hand it over to you.
What we're talking about here is the First Amendment to the United States Constitution. And how cool is that? I mean, that is just, to me, it's like, it makes my heart blurb a little bit, because I just think it's really powerful. And so when a person comes of age, the presumption is they're now have the ability to make their own choices. And the first step is if they're having problems with making choices, then to look at a supportive decision-making agreement. Somebody threw out this question about, well, what happens if there's an area where the person can't make a choice? And Alex talked about the way of crafting the supportive decision-making so that we can take into consideration all the ways that the person communicates to try and get the information. But another way to look at it is you could have a limited guardianship and a supportive decision-making agreement. So you could have a supportive decision-making agreement between the disabled person and the supporter that covers items 1, 2, 3, and 4, but you could have a limited guardianship for item number 5. And if you look back at this historically, prior to 1970, 71, you had to go into court and get a full guardianship. I started doing a lot of my guardianship work in about 81, and almost all of the ones that I filed, I just didn't like the idea of filing these guardianships, but I had to do it to get solve a problem for these clients. So almost in probably 95% of my cases, I filed them as limited guardians, limited guardianships. So the person retains some right of making a choice. And then, so you go from 1970 until, or 1980, let's say, until 2019, and then the supportive decision-making law comes into effect. So now you have 3 ways of looking at a situation. You have supportive decision-making, which is your primary way of doing it. You can have supportive decision-making with powers of attorney and other documents that the disabled person makes, not the court. Then you can have these voluntary documents done by the disabled person. Plus, you can have a limited guardianship for maybe some other area. And then the most restrictive course of action is to have a full guardianship. And so you have ways of solving all these problems, and it just depends on what the circumstances are in a particular case. The healthcare power of attorney, the way it really works, it was done at a time in 2015. It was a great effort, but people just didn't have the experience, and just, the research hadn't been done. The concept of supportive decision-making was kind of bursting on the seams of the law. And so what the healthcare power of attorney does for persons with a disability is it says, okay, for the first part, it's a supportive decision-making agreement, because it allows the person that makes the power of attorney to communicate their choices with the person that is going to help them. They can talk about it, and then the person that is their helper, it's not called a supporter in the document, I can't remember exactly, but that person can communicate the choice to the medical staff. And then what it says when I, the maker, the principal, can no longer communicate my choices, then my supporter becomes my agent. So it's kind of a springing concept. It springs from a supportive decision-making into a regular durable power of attorney for healthcare. And then it says at that point, the person can make choices for me based upon their understanding of my wishes. Okay, so it's a pretty good concept. One of the things we've tried to do is blend the concept of a supportive decision-making agreement with these durable powers of attorney for healthcare. I might say that I think the idea of supportive decision-making should be in all healthcare power directives. So, at my age, I've tried to incorporate things beyond just healthcare decisions. In my power of attorney for myself and my wife, we've incorporated choices about, well, what happens if we need a placement outside the home, or maybe we need help at home? How's that going to be done? So we have a system set up that says, okay, our agent has to get independent evidence from our doctor or a care manager, something like that. And then that person, our agent, has to practice supportive decision-making concepts before they actually make a choice to move us or do something like that. So this thing is going to reach across the span of our lifetimes. And then if there's the next concept we want to go through is just some of the general policy choices in 162C. And the first is that what we're doing is we're recognizing that the person with a disability is the best person to make choices about them. Right? I think we can all get behind that totally. And it's best that the person with a disability is the ultimate decision maker about what's going to happen in their own life. They're going to be the planner. And the adult decision maker is at the center of the decision making. So those are the policies behind it. And the last thing to kind of think about is that in the statute, there's actually a section on the supporter. And it says that the supporter has legal standing to assist the principal. So that way you don't get into the situation where you walk into the doctor's office and the doctor or the education office and the person from the state says, where the doctor says, well, who are you? And they're saying that to the supporting person. Well, this document says they have standing to be in the meeting and they have standing to work with the person and participate in all aspects of this process. So those are the features that go behind the statute. So Alice is going to talk a little bit about limits on the actions of supporters and what they can't do.
And this is a real important part of supported decision-making. And that is the role of the supporter and what the supporter can do. Just to recap, you've got the person who is the individual, the principal, and you've got the individuals that they've selected, the supporters. But the supporters, because this is a lesser restrictive alternative to any type of substituted decision-making, the supporters have particular limitations in what they can do in order to give the most self-determination and decision-making ability to the individual. That First Amendment component that Hank was talking about, those fundamental rights pieces. So the law itself is very intentional about what a supporter cannot do. And so it goes through and identifies a supporter cannot exert undue influence. A supporter cannot make decisions. A supporter cannot obtain information without the person's consent. It cannot use information for purposes other than helping the person make decision. A supporter has to act with care, competence, and diligence, and also keep information privileged for the individual, if that is the desire of the individual. Also, there are ways in which agreements could be composed in a way that could give ongoing consent for involvement in educational decisions or healthcare decisions. But at the end of the day, it is all about the person, the principal, being able to make those decisions, and the others as supporters having a role to provide that context to allow that person to be interdependent and therefore live an inclusive life. So it's very important, and it's worth looking at the law. The law is quite direct in this piece, and it is a very, very important component. So let's just talk on the next slide about the agreement process. So we've got the people that are identified, the principal, the supporter. We've got the concept and the philosophy behind supported decision-making. We understand there's a law called the Supported Decision-Making Act, that it's the least restrictive alternative. But how do we execute something in Nevada that allows for supported decision-making to have an impact on an individual's life? Well, it's the creation of a supported decision-making agreement. And this is the document that you saw that gentleman in the video show to the doctor. This is the document that's used to identify supported decision-making in Nevada. And that document, there is, in fact, is not a template that we have in Nevada, because we understand that everybody's circumstances are going to be different, and that the agreement is going to look different for each individual. But there are some basic principles that are required under law for the agreement. And once you have this agreement and meet these items that I go through right now, you can have a supported decision-making agreement that could be used to support you and your family. First, the agreement, there's two, a person must enter into the agreement voluntarily and without coercion. So that means that basically the person wants to enter into that agreement. Also, and this is important, the person must understand the nature and effect of the agreement. So by entering into this agreement, the person understands what the agreement is. That's all that's really required as far as the person is concerned for entering into that agreement. Further, the law identifies that the agreement must be in writing, must be dated, must designate one or more supporters. So to have a supported decision-making agreement, you have to be able to identify somebody else to enter into the agreement with you. List the types of decisions that the supporter is authorized to assist with. List the types of decisions the supporters are not allowed to assist with, if applicable. Remember when we first started writing some supported decision-making agreements, this was one we wanted to make sure we get in to preserve the rights of the individuals where they say, no, I don't need supporters in that regard. Also be signed by the principal in the presence of two adult witnesses. Now, of course, the supporter can't be a witness because of a conflict there, but it's notable that the law identifies two adult witnesses. So no notary is required, just two adults who are not in either the principal or the supporters can sign this agreement. Once you have that in place, you have the ability to create that supported decision-making agreement. Now, I said we don't have templates or structures, but we do have different guidance. The Second Judicial District Court has a nice packet that advises individuals and creates forms that can be used as a supported decision-making agreement. We have this right here, which is a guide that was created by the statewide guardianship compliance office that walks through step by step the different items that we just reviewed so an individual can create the supported decision-making agreement. And Diana will send this out as resources after the conclusion of today's presentation. So you have these guides that can help, but again, you just have to meet those requirements and you can create that agreement. Also, in order to ensure that the agreement is used, you want to identify that agreement and communicate the fact that the agreement exists to those in the community who might be involved in the support of the individuals, service providers, doctors, etc. And it's also worth noting that the law identifies that the supported decision-making agreement, the existence of it cannot be used against the person later in guardianship, and that ultimately, through this process, by going through those few items, you have a supported decision-making agreement that allows supported decision-making to be the way in which you receive support and live your integrated and inclusive life. That's it in a nutshell, right there, just going through it. And I'm going to hand it over to Hank to talk a little bit more about the fact that this is an ongoing process still after this success of passing the law.
Okay, one of the things we want to think about is that decision-making it's kind of a learned skill. So Alex and I are working with some other attorneys on a guide for young students coming out of high school, and thinking about that, thinking about what we're talking about tonight. All of it's about learning how to make choices. So supportive decision-making is a learned skill. Supportive decision-making agreement, they can be changed, terminated. You can change because everyone's life changes, and you can have co-supporters. There can be successive alternate supporters. And sometimes you can change it because maybe the supported decision-making is no longer needed at all, or maybe it's no longer needed in a particular area that you've designated. So maybe you say, okay, I don't want to have a supporter for helping me choose where to live. So you can change it for that purpose. So with that, I think one of the things you can just think about is these things are flexible, they're usable. You have the supportive decision-making website. At the end of that, there's a number of links, and the links are to national organizations. There's a link to a supportive decision-making agreement that we kind of altered, but it's really from the state of South Carolina. I put it on there because I thought it was really nice and clear and easy. And after what we've talked about, I think what we're hoping that you can do is see that as service providers or people that are working with clients, I think it'd be very improper to kind of push people into this, but if you can refer them to the website or to the other information that we've presented here tonight, that's a good way to try and get the information out. So one of the things you want to do is use plain language. So in our agreements, we've tried to use everyday language, get out of the law, give information by visual or hearing methods. So when you're gathering information to present or give to the person who's the principal, think about ways to communicate. It can be by speaking, it can be by a visual presentation. Think about a way that the people are listening to what you're doing, provide extra time to discuss choices, create a list of the pros and cons of a decision, bring a supporter to important meetings to make notes. So just the fact that the supporter is going to go to the doctor's meeting and maybe won't say anything, but might take notes so that the issue can be talked about at home in a little more of a slower and more deliberative fashion. And the other thing is that the supportive decision agreement can help the person with the disability communicate with service providers, including the decisions of the person. So there was a time when there was an agency in town that wouldn't let the supporter come into the meeting. Well, that's not correct. They have to allow the supporter to come in and not only be in the meeting where the choices are being delivered by the principal, but they can help the person with a disability in their characterization of their choice. So with that, we'll turn it back to my dear friend Alex, and he'll take us home here a little bit.
Yes, thank you. And that discussion that Hank went through right there related to the tools to use in supported decision-making, those are some of the areas with the question before about how do we support an individual who might have some communication challenges. There are these different strategies that exist and so many more that are available on Hank's website as well. I will, if we go back one slide more, Diana, just real quickly, it's important to note that there's a whole landscape of legal documents that exist when it comes to decision-making and guardianship. And you see them all there. We've kind of gone through each of these. But ultimately, it's important to keep in mind that when we're talking about supported decision-making and we're talking about guardianship, that there's a lot of other options that are available too. And right at the bottom there, the plenary full guardianship, that's the last resort. That's the most restrictive situation for decision-making. And there's all these other arrangements. We didn't talk much about representative payee, but that's a Social Security Administration's appointment of an individual to act as a representative payee. And oftentimes with the guardianship of the estate, you are often able to achieve very similar goals with the representative payee structure, which is a lesser restrictive alternative to guardianship. So it's important to keep an eye out for these different documents. And if there is a guardianship hearing or a guardianship matter in court, these often do come up. When I'm in court, we do discuss all those lesser restrictive alternatives and find ways in which we might be able to obtain a lesser restrictive alternative to that full guardianship. Let's go, we'll skip over the slide and then we'll hand it over to a success story in a second after I address a couple of questions. The question here is, does a supported decision-making agreement need to be registered with the state? No, there's no registration. There's no need for that to be involved with the court, unless if you're using it as, say, an exhibit or evidence for why a guardianship needs to be terminated, but that's not filing it with the state. Also, I noticed a question about, do you have to include supported decision-making plan as part of your family trust? Well, the family trust could be incorporated into that particular agreement, but that's up to the individual to make that decision. And then the question of what is the intersection of the principal's choices, living on their own with personal supports, transportation, food preparation, bathing, etc., and the state funding to support these choices. That's a great question. And that's where the person-centered planning piece comes into play. You're having very similar type discussions in the person-centered planning arrangement to identify what the wants, desires, and needs are of the individual. And a supporter's role might be to assist in that intersection of options that exist as far as those types of supports. So the supporter could be involved in ensuring that those arrangements that exist for the individual in state services are identified by the individual, and that the decisions that the individual makes about those state services are done with support. So I think that's a great question. But before we talk more about the philosophy or about supported decision-making, let's talk and hear from an individual who has successfully gone from guardianship to supported decision-making. And this is something that some of us call the school to guardianship pipeline. In other words, individuals are receiving special education services or in school and then become the age of 18, become an adult, and are encouraged to enter into guardianship without looking at all of those other lesser restrictive alternatives. And this story is one of those stories where a guardianship was in place, and now there's a supported decision-making agreement. So I'm going to hand it over to the success story for today, Connor Fogel. Take it away, Connor.
Hi, I'm glad for like as a kid, I worked at your as a videographer, and when I was in school at Piccolo, they before everything they kind of forced the guardianship on my parents, and so that kind of scared my parents because they had no idea what that was. And when I heard about it, I was like, oh man, really? To me, I think that'll make me more disabled because now I got asked for permission and all that. So, fast forward a couple of years, in 2018, I heard a friend got his scholarship removed, and I was like, I had no idea that you could do that. So I was kind of scared to talk to my mom about it. I don't know why, but so I was surprised that she looked into it, and then it was a long, stressful process, but in 2019, we got the guardianship removed, and in the process, we were in a meeting with my lawyer, and it was me and my dad, and the lawyer said Well, there is a couple limits that I did not know about. One is you can't get married with guardianship, and me and the dad both look at each other. Oh no, that that's gotta go, cause that's one of my dreams is to get a family of my own. So that was in 2018, and now I make my own decisions, and I work a normal job, work on videos and do filming, and I also do my art in public and make art. And
There we go. Thank you for sharing, Connor. And this is the, when I asked Connor right after the guardianship was terminated, what his thoughts were on the topic. This was what you said, Connor. You said, I like how I can do things on my own without a guardian. I can do stuff on my own now, and I can get married and no one asks if I have a guardian. It's great. So that's an example of the success of supported decision making. And Connor, a couple of just points I wanted to highlight from your story, Connor. One is you saw the restrictions on rights and said, hey, no, this is this restriction on rights is troublesome. And your attorney
yeah,
did a fabulous job of articulating the structure of guardianship and then bringing to you this new technology that existed. And so definitely credit to your attorney for her work in being able to do just that. And also, I wanted to highlight how when you're talking about your story, Connor, you point out that now you have achieved you're living a self-determined inclusive life. You can see those pictures there, your artwork, your involvement as a digital media producer and editor, your involvement in the Path to Independence program. And those are decisions that you are making, and you're at the helm. And lastly, if you can go back to that picture, Diana, right there of the team, that is the example of what this type of legislation can produce. A community of supporters, the beloved community, and a way in which individuals can make their decisions and live a self-determined life. And so this is, Connor, you said it was stressful. You said it took a while. You were in a large portion of your adult life was under guardianship, but now through this advocacy and through this effort and through the creation of the Supported Decision-Making Act, now we have this environment where there is the ability for you to have all of those rights and not have any restrictions under a guardianship.
Yeah.
So thank you so much for sharing, Connor. And I see people here that are seem to be fans of yours. You had a longtime fan of your artwork on here, Connor, and others who are really happy to hear from you. And of course, thank you, Travis, for sharing the website for Connor. You might get some business out of this. I really like that, some of the animal pictures in the landscapes. I need to get a picture in my office behind me here. So thank you, Connor, for sharing your story with us.
thank you.
And we're near the tail end here. So let's talk a little bit about where we can go next, right? Where do we learn more? Well, this is the website that Hank and I have been talking about, and it really is an incredible website. Hank and the Self-Determination Law Project, Diana and Travis at the Center for Excellence of Disabilities, and a whole host of other advocates and some funders have been involved in this. The Governor's Council on Developmental Disabilities. I know the Gwynn Center helps fund some of these efforts, but this website has tools, resources, some of the videos you saw today. There's a picture right there of Governor Sisolak and some of the individuals who were responsible for passing this bill and getting it signed. This is specific to Nevada, and it's pretty impressive. So all the information can be found there. There's a lot of information about supported decision-making that are at a national level, but here we've got it right in Nevada. So that's www.sdmnevada.org. So check it out and you'll find all these resources. Also, this is a national resource. There has been a lot of effort at a national level to get different states to adopt supported decision-making laws and to create these alternatives for guardianship. You can learn about it more at this National Resource Center for Supported Decision-Making. Check it out and you can see how our state compares. And we have a pretty good law, I will say, in comparison to some of the other states that don't have supported decision-making just yet. And again, it's important to remember that guardianship laws are at a statewide level. There's no federal guardianship law. Let's see, what other resources do we have?
May I interject for just a second?
Oh, yes, jump right in, Hank. Yes.
We have a question about, it says, do you have to include your supportive decision-making plan as part of your family trust? This is a complicated issue, okay? And the reason for that is if you put it right into, if you say, I want my successor trustee to utilize supportive decision-making, or you say, I want my agent under my power of attorney for finances to utilize supportive decision-making, and then you go to the bank, your agent goes to the bank to do something, they're going to say, well, prove to us that your principal received supportive decision-making from you before you're coming down here to take out $3,000 to get the heater fixed. And so I'm really worried about it, okay, in terms of trying to coordinate it. So all I did in our trust for my wife and I, we each signed a separate document saying, we are asking our successor trustees under our trust, our agents under our power of attorney for finances, our agent under our power of attorney for health, and whatever else there is, to exercise or to exercise their power in a way that promotes supportive decision-making. And because you don't really have to have a supportive decision-making, maybe I shouldn't say that, because it's a concept. And if you have it in your head, then it'll work. And I guess at that point, if we wanted to make a decision-making at that point, we could. But at least I wanted to express to the family that that was what our goal was. And I think it would be dangerous to put it actually into the agreements, although I did put it into our healthcare power of attorney, not as it pertains to medical decisions, but as it pertains to social decisions about where you're going to live and that kind of stuff. Because if we're isolated and we can't drive, we can't get around, we're in the same situation as a lot of the students are. And so if our daughter's coming up and saying, well, I think we should do this. No, daughter, I want you to ask me what I want. Okay. So that's in the document. Okay. But it's as to the social issues, not as to the medical issues. But it's probably going to take a few years for the lawyers to work through that kind of a concept and figure out how to work it for the adults.
Yeah, that is right, Hank. And we're continuing to find ways in which we can expand the application and of the law and use the law in ways that benefit individuals and their families. Thank you for sharing that, Hank. I also will note that the American Civil Liberties Union, the ACLU, at a national level has a resource library that has a lot of meaningful and valuable resources and videos from around the country. And I know the ACLU in the state is also committed to supported decision-making. And of course, the Nevada Governor's Council on Developmental Disabilities has some very helpful fact sheets. Nevada Department of Health and Human Services, Division of Public and Behavioral Health helps fund programs and also has resources on their site. And of course, the Center for Excellence in Disabilities, Diana and Travis and Connor and so many others who are working every day to create an inclusive community. If there's any final questions on the topic, we have a few moments before we sign off. Do we have any questions? I will also say, of course, I'm here as Nevada Legal Services. We are statewide. So if you do have a legal issue and are eligible for our services, go to our website. You can do an online intake right there. We do work as attorneys for the protected person, and we do assist with supported decision-making agreements as well. Just lastly, I'd like to thank all of those involved. Hank Cavalera for really all of the support and knowledge in expanding the ability of the supported decision-making process to be something that we have in Nevada. So thank you so much to Hank and for the knowledge on today's presentation. Thank you for Connor for sharing your story. That shows that this law has actual impact on the lives of individuals. And thank you so much, Connor, for being here and sharing that with us. And it hopefully will give others the idea of how supported decision-making can apply to their particular situations. Also, thank you to Travis and the others at the Nevada Center for Excellence in Disabilities for putting on today's presentation. And of course, a thank you to Diana Rivetti for being at the helm of such great resources. There's more material to come in the coming weeks. Diana is steadily making sure that the word gets out to make sure that individuals know how to have that important time in the life of an individual with a disability, that transition period of time, to make sure that we have all of the tools available to make that happen. So thank you so much. It's been a pleasure and an honor to give this presentation with